You will sign these papers now.
No, this land is mine.
You have no choice!
These documents prove the claim. The land is ours.
The boundary is clear. You must comply.
I never thought I would
Sign
spend
now or
my
we
late
escalate.
years fighting the very people who were supposed to maintain order in our community. My name is David Miller. I'm 72 years old. I bought my 40 acres of land almost 30 years ago. Back then, it was just empty land outside the growing edge of the town. No HOA, no restrictions, just peace and open space. Over time, the town expanded. New neighborhoods came in, and eventually, an HOA was formed around the nearby properties. I was technically outside their core residential zone, but they still started sending notices. At first, it was small things. Unapproved fencing, vegetation management concerns, boundary clarification required. I ignored most of it. I wasn't part of their community, and my land was legal and properly registered. I had all the documents filed with the county. Clean ownership. No disputes. But then the tone changed. One morning, I received a thick envelope marked Legal Notice, Final Warning. It stated that my land was allegedly violating HOA expansion bylaws and that I was required to comply or face enforcement action. That was the first time I felt something was off. HOAs don't usually have authority over private acreage outside their registered jurisdiction. So I called my county records office. They confirmed what I already knew. My land was not under HOA governance. I thought that would end it. It didn't. 2 weeks later, another envelope arrived. This time it wasn't just letters. It was from a law firm, representing the HOA board of Meadow Ridge Community Association. They claimed there was a boundary integration clause in old zoning documents that allowed the HOA to enforce regulations on adjacent properties, including mine. It sounded complicated, but something about it didn't sit right. The language was vague, almost intentionally confusing. So I did something I hadn't done in years. I called a lawyer. A young attorney in the county reviewed the documents I received. He was quiet for a long time after reading them. Then he said something I still remember clearly. "Mr. Miller, this clause doesn't exist in any official record. Not in county archives. Not in state filings. It looks inserted." That was the first real crack in the story. Before I could even process it, things escalated. One evening, as I was working near my barn, a black SUV pulled up on my gravel road. 2 men stepped out, both wearing suits. One of them introduced himself as legal counsel for the HOA. He said they were there to initiate seizure proceedings unless I agreed to transfer a portion of my land into HOA jurisdiction. I remember laughing slightly at the word seizure. I told them calmly, "You can't seize private land that isn't under your authority." The younger lawyer didn't respond. The older one simply handed me another document packet. "This is your final opportunity to comply before we escalate." And then they left. That night, I didn't sleep. Something about the confidence in their behavior didn't feel like bluffing. It felt organized, coordinated. So the next morning, I did something I didn't expect. I contacted the county land records office again, this time asking for a full historical chain of ownership and zoning maps for my property and surrounding expansion zones. That's when things took a turn I didn't see coming. The clerk on the phone paused several times while reviewing the records. Then she said, "Mr. Miller, there are recent amendments filed here, but they were not processed through normal county approval channels." I asked her what she meant. She replied carefully, "It looks like someone attempted to modify jurisdictional overlays using external filings, not official zoning board procedures." That's when I was told something else. A formal investigation had already been opened, not by the HOA, but by a state-level regulatory compliance unit. And my property was part of a broader review. I didn't even know what that meant at the time. All I knew was this: the HOA lawyers who had come to my door might not have been acting alone, and someone else was already watching everything. That was the moment I realized this wasn't just about my 40 acres anymore. It was about something much bigger hiding behind it. The next morning, everything felt different. Not physically, nothing had changed outside. My land was still the same. The fence still stood. The barn still creaked in the wind like it always had. But mentally, I knew I was no longer dealing with just an HOA dispute. I was dealing with something that had already attracted outside attention. 2 days after the phone call from the county clerk, I received a direct letter, not from the HOA this time, and not from their lawyers. It was from a state compliance investigator. The letter was short and precise. It stated that irregular zoning amendments had been flagged in multiple properties within the region, and my land had been listed as a reference point in disputed jurisdiction mapping. That phrase stuck with me. Disputed jurisdiction mapping. It sounded technical, but also intentional. Like someone had been quietly redrawing boundaries without public approval. I was asked to provide all correspondence I had received from the HOA and their legal representatives. That same afternoon, I received another visit. But this time, it wasn't the HOA lawyers. It was an investigator and a county auditor. They didn't come with threats. They came with questions. They sat at my kitchen table, going through every notice, every letter, every legal packet I had saved. The investigator was calm, almost methodical. He kept separating documents into two piles. After about an hour, he finally spoke. "Mr. Miller, these notices are not consistent with any legally recognized HOA enforcement structure." Then he placed one of the documents on the table. "This signature here belongs to a law firm that was dissolved 3 years ago." That's when the entire situation shifted from confusing to serious. The auditor leaned back slightly and said, "This is no longer a private HOA matter. This is now a jurisdictional fraud investigation." I remember just sitting there, trying to process the words. Fraud, jurisdiction, fake authority. It didn't feel real. Later that week, things escalated quickly. The same lawyers who had come to my property earlier were now subpoenaed for questioning. The HOA board members were asked to provide original documentation for their claimed expansion authority. And suddenly, silence. No more letters. No more threats. Just silence. A week later, I got a final update from the investigator. What they found was more complicated than I expected. The HOA had been operating under expanded boundaries that were never officially approved by the county. Some of the documents they relied on had been digitally altered during a system transition years ago, something that had gone unnoticed until now. My property wasn't the only one affected. Several landowners were listed under incorrect enforcement zones. But what mattered most was this. The attempt to seize my land was not legally valid at any stage. It had been built on false jurisdictional assumptions. And the lawyers who came to my door? They were now part of an active investigation into professional misconduct and misrepresentation. A month later, I received one final letter. The HOA was required to remove all enforcement claims against my property. Any prior notices were officially void. No apology was included, just closure. But for me, the real ending wasn't the paperwork. It was standing outside my land one evening, looking at 40 acres that had nearly been taken from me, not by force, but by paperwork that was never supposed to exist. And I kept thinking how easily it could have gone the other way, if no one had checked. That's the part people don't realize. Sometimes, the biggest battles aren't fought on land. They're fought in documents no one bothers to read. And in my case, reading them changed everything.